Welcome to week 1 of conciliation. This week we will be evaluating what is conciliation. Litigation is expensive and it usually takes a long time to resolve the issues, whereas people who want to deal with alternative dispute resolution methods usually want a strong and effective change to their issue. The Labour Relations Act needed some revision after the introduction of the interim and final constitution, and therefore the 1995 revision of the LRA made leaps and bounds to put the parties in a position to meaningfully collaborate with one another. The need to use alternative dispute resolution methods is not only to avoid litigation, but it allows the parties to avoid the antics and costs attached to them. Conciliation is a dispute resolution technique where a neutral conciliator works with opposed parties to help them establish a common ground, as well as allow them to identify the strengths and weaknesses in their positions. Conciliation allows for both parties to consider how the matter before the conciliator could progress in the event of conciliation failing. This means during conciliation, the parties are looking for an opportunity to resolve the issues by opening the lines of communication. Unlike a mediator, a conciliator injects their insight and opinions, as well as a view of how things might turn out. They suggest possible solutions to the parties and weigh in on the exposures and costs associated with failing to reach an agreement. Sometimes parties will walk away happy and sometimes not. Usually, conciliators help parties to agree on what they disagree on, which, should the matter proceed to court, the consensus is incredibly insightful. The CCMA defines conciliation as the process where a commissioner meets with the parties to a dispute and explores with them ways to settle the dispute by agreement. We need to remember that there are time limitations on a matter when it can be referred to conciliation. Why do you think this is the case? This is because the longer an issue festers between the parties, the more resentment can grow. Conciliation can only occur when the issue is governed under certain pieces of legislation. A few examples are the Employment Equity Act, the Labour Relations Act, and the Basic Conditions of Employment Act. The intention aligned to conciliation is for the parties to be able to continue their relationship in a meaningful manner. Sometimes disputes arise between parties, but that doesn't mean the relationship needs to be severed. Conciliation can be used to honor each party's point of view while keeping the parties connected with the long-term goal of maintaining the relationship. Conciliation is used as the platform for the conciliator to provide an informed opinion on what the best next steps can be. Why would we choose conciliation? It is efficient. We hope to resolve matters as soon as possible, and while we want a speedy resolution, we do not want to compromise on the integrity of meaningful collaborative discussions. The goal of efficiency should never be used as justification for disrespecting the rights and interests of the parties, no matter how tempting it may be to resolve the dispute without due regard or for fairness. Conciliation is informal. While there is a process that conciliation follows, it is not a burdensome one. Conciliation is also accessible. While you are not forced to communicate, you are encouraged to do so. And most importantly, communication in conciliation is done so without prejudice. This allows the parties to be able to speak freely and openly, knowing that what they share will not be held against them at a later stage. There is limited representation at conciliations. Often you can have a trade union representative or represent yourself, but generally at this stage, trying to resolve the dispute, legal representatives could harm more than heal. Take a moment to read this quote. Thank you for your time this week.